I did broadcast.
Cool.
So 2 attendees so far. Do we need to admit them?
No.
Okay. Welcome, Anita, Annie, Jackie, Jessica, Kim, Lisa, Stephanie, and the list keeps growing. Welcome. This is Margaret Barrett from Safe Harbor Estate Law and Megan Swenson. And we just, first of all, want to make sure that you can hear us today and see us today. And so if you would be so kind, please go to the chat at the bottom. It's in the middle. If you put your mouse at the bottom in the middle, there's a little chat box. And just say like, yes, I hear you. And I will give you a little note right now myself. Oops. Hello. Yes, I hear you from Kim, Dick, Michelle, Heather. Well, they're coming fast. I don't know if I can read them all that quick. Anita, Annie, Pam, very good. So glad you can hear. Super. Good morning, Lisa, Joanne, Jackie. So glad to see you all. 16 people so far. I think we had about 30 sign up, Megan.
Yes.
But of course, not always, not everybody can make it. That's how these things are. So our time is 2 minutes after 10. We'll maybe wait another minute. Patrice, welcome. Jackie, Lisa, Alice, licensed social worker. Great to have you here. Pam. Okay, so if any of you already knew me before, could you write me a little note there? Because a lot of these names aren't familiar. And the drawback of the presentation mode of Zoom is that I can't see you. So that makes it harder for me to remember. So otherwise, it's a great opportunity to present to new people. And okay, no one's saying they already knew me. So another question I have while we're waiting is if there's anything in particular you're looking and hoping that I covered today, please let me know. I would like to know that too. Otherwise, there will be time for questions at the end. Peter's here. Thank you, Peter. Okay. Let's see. Should we go ahead and start, Megan? I think it's about 3 minutes after. We want to make good use of your time. We thank you very much for taking the time to be with us today. It's an honor. Oh, how the criteria for guardianship has changed over time. Okay. I'm gonna have to do that on a one-on-one, Jessica, but we'll see how, okay. Or maybe at the end with the questions. Oh, yes. So when you're chatting, there's 2 choices. You can pick all panelists and then only Megan and I can see it, which is fine if that's what you want. But a lot of times people want everyone to see it and it's helpful for everybody. So you can choose all panelists and attendees, which is not the default. So you just click the little button and the little down arrow, and then you can choose that. Your comments can go to everybody. Somebody might have the same question that you have. Okay, welcome to what you need to know about guardianship and conservatorship. We just put up the PowerPoint. So again, if you could please put in the chat if you can see the PowerPoint. Because sometimes we had yesterday one person who couldn't see it. I see it, Heather, Jessica. Okay, great. All right, let me know if you see any problems, Megan, with the people being able to see the PowerPoint. Okay, we are so honored, we at Safe Harbor Estate Law are so honored to partner with Village Shores community who invited us to host this. And I'm not sure if Judy is on. I don't remember seeing her this morning. But Judy Kosnick is the Director of Marketing now, and I think someone else, her predecessor, invited us. And so we're really honored to partner with them today. And I want to start out by talking about why I think this is important and what a difference a guardianship can make in the life of a senior or a person in need and their family. So this is a story, true story, about 2 years ago. A woman called, I'll call her Kathy. She lived in Washington State, and her mom lived here, and her brother and sister. Her brother and sister had really shut her out of things involving her mom. She still had contact with her mom, and she knew her mom was failing, but her brother hadn't talked to her in years. She didn't know why. Her sister would give her a little information. They were all three on the healthcare directive, so that's why she knew a little bit. But she was really concerned. Her mom was still living at home. She went to daycare a couple times a week. She had dementia. And her brother would come and stay with her on the weekends. But she was alone a lot of the time. And from the medical records and from her conversation, she was concerned that that was too much. And so she contacted me, and we talked about it. And she really had a hard time with it, because she felt like my brother and sister will probably never talk to me about this. But on the other hand, I'm concerned about my mom's safety. And it was a big decision, understandably. So we had started working on it. And then 2 years ago in July, she called, and there was a crisis, because a neighbor had found her mom in the front yard. It was about 80 something that day, fainted in the yard on a hot afternoon. And it was very concerning. They got her to ER. It was no permanent damage or anything like that. But when she talked to her sister about it afterward, it was minimized. They weren't planning to make any changes. They weren't going to give her any more supervision. They were just going to leave her as is. And so she was really alarmed and felt like her mom actually could have died. And I did too. I felt like this is really urgent. So we kind of cleared off our workload and made this a top priority, as she wanted us to do. And we brought an emergency petition for guardianship conservatorship. It ended up in the end to be very good result, even though it was very hard for our client to have the courage to do this. They got a professional guardian conservator appointed. She came in and found out about the finances. The mom had $1 million, and every time Kathy would bring up getting care, her sister would say it costs too much. They didn't want to spend any of mom's money on care. So that became clear, and it became clear how badly she was doing. They didn't realize she was up at night wandering, and no idea, didn't realize she wasn't getting enough food. So it became clear that she needed to go in a facility, and she did. And in the facility, she thrived. She was getting care, she was getting food and water, and she was monitored. And she's been doing really well there and really happy there. And another really neat thing is the brother called my client and apologized for not talking to her all these years. So they're really working together. And after the emergency guardianship was over, we were able to discharge the guardian, and the family's working together. And so it was really a win-win, and my client was really glad that she went ahead and did that. Everyone's really in a better place right now. So that's the kind of difference a guardianship conservatorship can make. Another question I want to ask you guys, let me know if you've been involved in a guardianship conservatorship, and you can, if you want us to describe a little bit about it, that'd be great. So this is our team at Safe Harbor State Law. We help families protect what is most important to them. And Megan Swenson is over on the right. She's our Director of Client Relations. She's the first person potential clients talk to, answers a lot of questions, also talks to a lot of senior workers when they have questions. So Megan's on today, and then I'm in the middle, the tall blonde and the shorter brunette, older. But it's very typically people will work with quite a few people on the team. Okay, so nobody said anything about being involved in a guardianship. So you could say yes or no, because I am curious about that. It kind of helps me to understand what your experience is. Okay, then we have a slide for Village Shores, or did we already see that? Let me see. Nope. Okay, so next is about my personal experience. And I just want you to know, we haven't had a guardianship conservatorship in my family, but we've had a lot. My dad died of dementia last year. And so for years, my siblings and I supported my parents through that. And now it's just my mom, who's 88, and we are supporting her. And we thankfully have not had to do that because they have their paperwork in order. We haven't had to do a guardianship. But in my family, years ago, we had a long 7-year litigation lawsuit fight over an estate that went to the Minnesota Supreme Court. Learned a lot from that. I want to help my clients avoid that. I'm in a blended family. And so I know how those dynamics are and how important it is to prevent problems. A lot of guardianship conservatorships come out of blended family disputes. So, so I'm just personally really motivated. I want my clients to sleep better at night, knowing that they've done all they can. We can't prevent bad things from happening, but we can do all we can to minimize the difficulty. And the next slide will show you just some professional credentials that you might be interested in. I've started my firm 7 years ago. I have some good reviews. I'm involved in the legal community. Last year when they were the 16th fastest growing law firm in the country, fastest in Minnesota, because there's a lot of people to help. And we're glad that we're able to help more people all the time. So I want to go over today a roadmap for you of where we're going to go now that we got kind of the background information out of the way. Okay, Sally Silk. Sally Silk, you've been involved in guardianship, I bet. Okay. Okay, explain guardianship and conservatorship. I'll be walking you through that. And it's going to include practical information you can use to help seniors. I have a free gift for you at the end that I think will help with that. And we have time for questions. So please do put questions in the chat as we go, but there will be a dedicated question time at the end. And then if we can't answer your questions today, you can have a one-on-one with Megan afterward to answer questions, because we know things come up and people aren't sure what to do. You can always just send a potential client to us and we'll help figure them out if we can help. But sometimes you want to ask us directly, and we're okay with that too. So what is a guardian or a conservator? The first one I'm going to talk about is the guardian. These are both people who are court appointed, and the guardian protects what's called the ward. So the person who, say here, the elderly woman would be called the ward. It's just a legal term. And I'm going to use that term throughout the presentation. And the guardian is the one whose job it is to protect her or him. And a guardian handles personal decisions. For example, healthcare decisions, deciding where the person lives, who the doctor is, visits with family. You may have something to say about that. Not legal and financial matters, just the personal. That's what the guardian is. Think of, it's the same name. A guardian is a person who, if a parent dies and your child is under 18, a guardian's appointed to take care of them. Not finance and legal, but all the personal and health concerns. The conservator, on the other hand, is Minnesota's name for the person who handles finances and legal. And now we call the ward a protected person. It's a different name. So a lot of times you get both a guardian and conservator, but you can get one or the other, either way. So an example of what a conservator is: pay bills, sign a contract, applies for medical assistance, and you have to file reports with the state regarding how the finances of the person are going. A lot of times, some of you are working with senior facilities, you work at senior facilities, and so we'll get a call about this kind of thing when somebody's broke a hip moving in, and somebody needs to sign the contract, and there's no power of attorney, no one can sign it. Also same with applying for medical assistance. Sometimes no one has the authority and the person can't do it anymore. So that's when a conservator can be used. I'm going to give you a little kind of a cheat sheet to remember guardian and conservator. Having a guardian is sort of like having a healthcare agent. So if you have a healthcare directive, you probably won't need a guardian unless your family's fighting over it, over who's not doing a good job. Same for conservator. If you have a good power of attorney, you probably won't need a conservator unless there's a problem that comes up. So good planning ahead with an estate planning attorney, like we do this too, can avoid the need for guardian or conservator. But of course, we all know that not everybody plans ahead. So the goal of both is to protect the vulnerable person in the least restrictive way. This is what the courts are looking for. they don't want to take away any rights that that the person could actually handle. Like, let's say maybe they can't really handle their finances, but they can still vote, you know. Maybe they need some help with healthcare decisions, but they can still have some walking around money that they can spend, but they can't spend all the money. They want to just restrict freedoms as little as possible to still protect the person. So the court is always going to get involved in these. And just remember, the goal is to protect the person in the least restrictive way. So this is a testimonial from, it's actually the client who I told you about at the beginning, Kathy, the mom who really, we felt like we possibly saved her life, but really saved the whole family situation besides her health. And she just said, due to family disagreements, she wanted to support her mom. She was out of town. She worked with us. She found us helpful and supportive, and we did work nonstop, but it was so worthwhile. And we did listen to her ideas. Of course, that's really important in this kind of situation, especially, and gave some direction, and we're able to, we did have to go to court on that one. We reached a settlement, but we still had to spend some time in court, and that went well. So she was really pleased to work with us, and it's just an example of sometimes these can just work amazingly well. The second segment now is who needs a guardian or conservator? What problems do they solve? I thought the best way to tell you this in a way you could remember is to just give you some stories about actual clients that we have had. Here's a picture of my mom and dad. The story isn't about them, but you know, I just like to have their picture in here. Lack of planning for dementia. So this was a client who, the sweetest people, had done no estate planning, and the husband had Lewy body dementia, Chuck. And then he had some kind of a physical illness, but it affected Lewy bodies and made it take a turn for the worse. And so when they called me, they were in a facility and they couldn't sign the paperwork to stay there. And so I was hoping that Chuck had capacity and he could still sign a power of attorney so his wife could take care of things for him, because he handled all the finances, of course. She really hardly knew anything about the finances. So we met there, actually met the whole family. And unfortunately, like we feared, Chuck had really taken a turn for the worse, and there was no way he could sign anything. So we did have to do a guardianship conservatorship in that case, and Ramsey County, we got it, didn't take too long, and I'll tell you more about the process later, but we got it all appointed, we got her appointed, and then she started accessing the financial statements and finding out where the money is and signed the contract, and then sadly he died in a few weeks. So we were going to do more, but it was helpful for those couple months at least that he was appointed. I would have rather he had his paperwork done ahead of time, but as it was, we were able to help them, and they were really thankful about that. So that's my first example. And the next example is family not adequately protecting the elder. Okay, this one, I have to skip up in my pages. This is the story that I started with, my client, Kathy. And in this case, I want you to know the paperwork was done well. It was done by a different attorney. The healthcare director was in place. The power of attorney was in place. She actually had a good trust. The problem was the family wasn't acting in the best interest. I think the son and his sister were a little bit of denial about how bad mom was. And then they had this kind of cheap mentality about not spending mom's money that I think they just didn't have experience with this kind of thing, and that's kind of understandable. So again, sometimes it's really the family dynamic, and some of you have probably seen that. The next one is, I had a case that was a big family dispute, but the reason we got a guardianship in Minnesota was because he moved back to Minnesota. So my client was Nancy, and her dad had moved to Arizona for years, and he had a a girlfriend there, a significant other, and he lived with her. But things started to go downhill. She was charging him a lot of rent. The family had a lot of concerns. She had him change paperwork, etc. So down in Nevada, his granddaughter had sought to be guardian conservator of him because of these red flags with his significant other, as he had dementia, by the way. And so there was a big battle down there. That down there was about $100,000 of legal fees. And then he came up here for a visit, and he decided he wants to stay with his kids. He didn't care about the significant other anymore, and he was done. So that's when I got involved. So this one was a little more involved. I was involved in the hearing down in Nevada over the phone, and we were involved in, there's a transfer to Minnesota. So a little more complicated, a little more money. He had about a $2 million estate, so he definitely had the money to do it and well. And so we got the daughter appointed in Minnesota. He got settled here very well. He's still doing well. It's been about 2 years. So that's another example. Moving was kind of the big issue, but also the dispute within the family. Next story I have, gosh, they're all sad, but there's, at least we can help them. 59-year-old woman, her and her husband were separated 4 years, and they just weren't getting divorced because he was a really nice guy, my client, and he wanted to keep her on his medical insurance. So she fell down the steps and had a brain injury at age 59, and she's physically very healthy, going to be in a nursing home the rest of her life, could easily be 20, 30 years. Well, he had been working hard and hoping to retire eventually, and he didn't want to spend all his retirement on her care. So there was a little bit of complexity here because we had to figure out, did a divorce make sense, and et cetera. But she had no papers, so he had to be appointed guardian. We ended up having a professional fiduciary, because there's professionals you can hire to be guardian conservator, and that made sense here because the conservator needed to divorce him. They were going to get divorced, and he couldn't obviously be on both sides of the divorce. He couldn't represent her best interests in the divorce. So that one, we were able to help and get the paperwork. It was a very stressful time for him, but you know, he got through it and ended up to protect his money as best he could, while she still could get good care and qualify for medical assistance when her money runs out. So that was another example of a younger person. And my last one is really young. This woman was about 30. She lived in Minnesota. She went to Colorado to visit her dad, and she fell ill there. And she was not able to handle her affairs, and she was in and out of the hospital for about a month. And so her dad and her sister were scrambling to figure out what bills need to be paid in Minnesota, what, you know, access to her accounts and everything. So they wanted to start a guardianship conservatorship, but then she suddenly died. It was really sad and tragic. So we ended up handling the estate. So it can happen at any age. And there's many times where we start out thinking, is it going to be a guardianship conservatorship, or is it something we can avoid because I actually can get the people to sign the papers and they do have capacity? And those are always really big wins. I just had one of those last week. I was out in a tent at a facility, meeting with a woman 6 feet apart with masks on, and she did really well with her capacity that day, and she was able to sign her power of attorney, and I was so happy to tell the family no guardianship needed. So we don't always get to the guardianship when that's the first concern. Sometimes we can avoid it, and we just do whatever's best in the situation. These are some red flags, kind of a summary of those stories for you to watch for. And I have a free resource for you you'll get afterward that'll have a longer list. But first of all, if the client can't handle their affairs, sometimes you senior professionals are the first people that notice that. If you need access to finances, a lot of times this is the issue. The bills can't get paid. We can't get to the account. The bank won't give us access. You might need an application, like a medical assistance application or a contract signed. If the family's not acting in the best interest, or if it's pretty suspicious. A lot of times when the families are fighting over the best interest, the court will lean toward a professional. And a lot of times that's a good idea, especially if there's money there, because it's a neutral and it can help calm things down. And then sometimes the guardian conservator is already appointed, but they need help and they have questions. And so we sometimes represent them and help them. Sometimes the documents need correction. There were mistakes made in them, and and they just need to be corrected. And conservators can actually change wills. They need approval of the court, but it can be done. And sometimes it's very much worth the hassle and the money. And of course, another case I'm not really talking much about today is if you have a special need child, they're turning 18, the law considers them an adult and able to make all their financial and legal and medical decisions. And so if you or someone you know has a child who is not going to be ready to make all those well, then normally the parents will seek to become guardian and or conservator of the child. And that's really rather routine, quite common, so long as the child really needs that kind of assistance in making decisions. So those are just red flags people in your situation can watch for. I don't expect you to remember all the details. I hope this has given you enough background for what you're looking for today. But I just really want to empower you to be able to spot issues and know when an elder lawyer could possibly help. So this is a son, one of those cases, it was only a couple months ago, where we avoided guardianship. He called his mom. She was only about 72, fell and broke her hip. And so she was in the hospital. Then she was in the transitional care unit. And they let me go meet her there. This was a couple months ago during COVID. And she was able to sign a power of attorney and healthcare directive. And we avoided the guardianship. And we did go way and above and beyond. I think they hired us, and the next day I was over there and we got it signed, and it was super. And he was losing hope. And they've been through a lot, because she went back home, and then after 2 weeks, she was back in the hospital. Now she's in the facility long-term. And he just emailed us yesterday that we're going to keep working with him, and actually him and his wife as well. So the next the next topic is the process. So we've covered, what is a guardian and conservator? And then who needs them? What kind of problems do they solve? So this is the actual legal process. And we call it the smooth sailing process. That's our name, because for all of our services, we have a process to help clients understand. We have a diagram to help them kind of understand step 1, step 2, step 3. So we call it smooth sailing, because there's always rough seas that come up in life, and we want to help people get through them as smooth as possible. So the first point is that the court is always involved. You cannot get a guardian conservator without petitioning the court. And that is because the court wants to protect people. So we recommend, and most people do, hire a lawyer to help them get it done. There is always a risk that the judge could say, no, I'm not going to appoint this guardian conservator. You haven't really made the best case for it. Or whatever. So it's really good to do it right from the beginning, especially if there might be any kind of contention. So the court's going to determine if the legal standard are met. And I'm not going to go into all the details. It's a little bit different for the guardian than the conservator. You definitely will need a medical opinion. That will be part of it. You may have battling medical opinions. You will have a couple, probably 2 or 3 different legal opinions for the judge to consider, the medical records, and the petition of the person asking, which is supposed to have a lot of details. It takes details. You can't just come in without detailed examples. So that court is going to be careful in making sure the legal standard is met. And then lastly, you probably know this, it might be initiated by the care facility themselves. Sometimes there isn't a family to do it, and it needs to be done. And I've been involved in some of those. Oops. I was trying to check on the chat to see if you're okay. Okay, good. So that's the basic. This is the big question. And from the first meeting with the client, I'm thinking about this question. Will less restrictive measures work? That's because it's the legal standard. If you can give the person more freedom and less restrictions and still protect them, that is what the court is looking for. So if I come in and petition the court for guardian conservatorship, I have to show these are the things that won't work. We've considered them, and here's why they won't work. For example, power of attorney and healthcare directive. Either they don't have one, or it's not working because the person's misusing it, or they only named one person and that person died. That happened to us this last year. There's only one person on the POA, the husband, and he died first. We had to go do a guardianship, conservatorship for the wife. And so I always recommend people name more backups to avoid that problem. So that's a great, less restrictive measure. Things like having a rep payee for Social Security on your accounts, or someone who's maybe joint on the checking, has some kind of authority to pay bills. Living in assisted living can help, as you know, just if it's help with care or kind of monitoring, that can help, or having a care company that comes into the home and helps you out, or a family member, some kind of companion care. Supported decision-making. Oh, I forgot I added one on this slide. Technology. This is actually right in the law. You know, is there any technology that could make a difference for this person? And that could be from, you know, the GrandPad. I don't know if that would help, but any kind of technology that might help it, especially if a person maybe has impaired vision or something like that. There might be technology that could make a difference. And then supported decision-making. Can you please put in chat if you know about supportive decision-making? This is new, and somebody at the beginning, oh, Annie Lane, good, asked, you know, how has it changed over time? I would say this is something that has changed. There's a movement toward empowering people with vulnerabilities to make their own decisions as much as possible. So guardianship, conservatorship, there's going to be a long list of boxes to check. Like, Your Honor, I'm asking for the power to do often we're asking for all the things, you know, maybe except voting. But you can have a more limited guardianship where they only need help with X, Y, and Z. Most of the ones I've handled, they need help with everything. So it tends to be kind of black and white. Either this person's doing everything for me and I can't do anything, or I'm doing it myself and I may not be doing it very well. Supported decision-making is a new movement where you really come to an agreement. Let's say a parent and a young adult. I have a client who did this with his young adult son who has some mental illness. And they have an agreement about how dad's going to be involved some in the decisions. And so this really allows them to feel respected and empowered and to use the skills they have, but also an agreement where they're going to include dad in the decisions. So supported decision-making is a whole new realm. And Volunteers of America in Minneapolis, their elder law organization there, and John Kantke in particular, part of his job is promoting supported decision-making in Minnesota. Honestly, most of the cases I get are more on the other end where they need all the help. But I have had some, like the client I just told you about, that supported decision-making was part of what we did. Last is a special needs trust or an ABLE account. So if somebody doesn't handle money that well, if it's a special needs trust and maybe Lutheran Social Services administering it, they can help kind of make sure the money's going in a more helpful way, and maybe some of it isn't spent that wisely, but there's a lot of people without special needs that don't spend money wisely. So that can be a protection that doesn't go as far. So when we have a potential new client, we'll talk to them about, is there anything we can do less restrictive? Because this must be met before we could even look at a guardianship, conservatorship. Next, I want to talk about the court process. So we need to draft a petition with detailed facts. Once we've decided, yes, we think that this needs to be guardianship, conservatorship, and we can support and prove that to the court, this is where we kind of got to press the client to really give me details. Like, well, what does dad do with cash? And how did he used to handle bills? And what does he do now? And just really some specific examples. And you may at times be able to help with those because some clients struggle more than others. But we really want to present a really accurate picture of what's going on with this client so that the judge feels comfortable understanding, and it's not just summary descriptions. Then we file the petition with the court, and notice goes to all interested persons. Now, have any of you received notice? Because one of the people who gets notice is the facility the person lives at, their spouse, their siblings, their kids. There's a lot of people who get notice, kind of anybody who we think might have an interest. Even a significant other would be included. So notice is served on all interested persons. Then the court is going to appoint an attorney for the ward or protected person, their own attorney. And by the way, they end up paying for it unless they don't have money. And depends on the county, they also get a visitor who the court visitor, both of them would visit or meet with them. And they're going to give their independent report to the court about what they think, if they have capacity or not. And they don't always agree. The attorneys and the court visitor don't always agree. So, but that is again to protect the person. And then there's a hearing. So there's always a hearing. If it's contested, it's a bigger deal. If it's not, this judge is still going to be pretty detailed and want to make sure that this makes sense for the person and that the order is crafted to be just exactly what they need. And so the timeline of this whole thing is, it's going to depend. So it depends partly on the county, and it depends on if you're doing emergency or traditional. So in emergency, we're on the next one, Megan. I don't know if it's a slowly changing the slide. There we go. Oh, maybe the slides aren't in the right order. Sorry. Okay, I see. Okay, so, well, I'll just tell you, the emergency hearing, that's what we had to do with the lady who, fainted in her yard. We were worried about her health. You can usually get in, depending on the county, in like a week. And there isn't much notice, and they'll just appoint somebody. And I've done quite a few of those. And then, but they'll only last for like maybe 30 days usually. I have had them last longer, which is not what the statute allows, but anyway, sometimes the judges go a little bit outside of that. So the one where the lady fainted in her yard, we got the appointment, and then it was good for 30 days, but the judge extended a little longer because it was going well, and we actually got her discharged and the family took over. So that's what an emergency is designed for. But normally you do the emergency, then you kind of have to do the whole thing again to do it for past the first 30 days. And you can save some time because the petition's similar, the facts can be similar. But the idea with the second hearing is everybody gets notice, everybody gets heard, and we really get a long-term solution. Obviously costs more if you have to do both. If you can wait on the Guardian, a lot of times the hearing's maybe a month after. It's really going to vary by the county, especially with COVID. And also these hearings are virtual right now, and they never stopped them during COVID because they think if it's an emergency, it's an emergency. And I had one going on during COVID that we actually settled by mediation. So we didn't have the hearing. So should we go back to the last slide, Megan, that I did out of order? Sorry, it's not easy. We were going to have me do the slides, but at the last minute we switched it up. So that's making it a little harder. Okay, so the goal of the hearing was to get someone appointed. So once the judge decides I'm appointing a guardian and or conservator, whether it's a person, a family member, a friend, a professional, there has to be a background check. It's actually done before the hearing, but they have to have a background check with the state. They have to post some kind of bond, usually. Even the woman, the husband that had Lewy body dementia, and the wife, everything was joint in their lives, and she got appointed to take care of his finances. She had to post a bond. So that's really common, so that if they steal money, there's some kind of protection there. And then if everything goes okay, then letters are issued. It's like one piece of paper. It's, instead of calling it a letter, it's called letters. So it's the letters, and the letters is going to give the guardian or conservator authority to act. So that's our goal. We get the letters, and then once they start providing those to the financial institutions, the doctors, etc., then they can start acting on behalf of the ward or the protected person. That is the goal. So once they're appointed and they have the letters, they can get that. Oh, sorry. I need to be looking in a different place than what I'm looking. The cost. I would say the cost, I would estimate normally about 3,000 to, you know, the one I told you about Nevada, that big fight was 100,000. There isn't really much of a limit at the top end, but that's unusual. It is normally paid by the ward. If the ward doesn't have money, there's a way to work around that. And sometimes the county will bring an action and for the ward. And, but normally it's paid by the ward. Sometimes a family member will pay them up front. And then once they win, then the ward will pay. If they bring a motion or a petition for guardian conservator and they lose, the ward probably won't pay unless they want to. So the factors and costs are going to be how complicated it is, and disputes is a big one, and how many hearings. So normally there's just one hearing or two if there's an emergency, but if you have to go back and get permission for a divorce or permission for a will, or, you know, if you want to step down and appoint someone else a year later, it just always costs money because there needs to be a hearing for these things. IFP, that stands for informa pauperis. So that is a way where the courts can provide savings on fees and provide legal services for no charge for the indigent, wards, and protected persons. And we have helped people do that before too. So once the guardian's appointed, they're going to be able to get access to information, and that is going to make the big difference. So that they can go back in time and see if someone who is suspected of stealing money did steal the money, and they can actually bring a lawsuit against them to recover it. That would be going back to court. But basically finding out what's really been happening, what's the medical situation, take them to appointments, and then they have the power to act. So based on what they find out, they can act in the best interests of the ward. They have a fiduciary duty to protect. That in the law, a fiduciary duty is the highest duty there is. So they must always act in the best interest of that person. And if that fiduciary duty is violated, they're liable for that. And of course, they could be removed. The guardian conservator must make regular reports to the court. The guardian's going to make at least an annual report, normally well-being report it's called, like, and let the court know how it's going. And then from time to time, there'll be a hearing on it. The conservator has to report. There's a good system online. A lot of people can do it themselves without having an attorney do it, but there's a system online, MyMMC, to report for the conservator to the courts about what's happening. And then after a person dies, you have to go and put in a final report and be discharged. So it's really potential for going back to court again. So we are just about done with, and just about up to the questions. Thank you for hanging in there with me. So this is a grandson who we worked with last year, and his grandma passed away a few months ago during COVID. And he just felt like a quick phone call with us, which would have been with Megan, made him feel like there's hope in getting everything taken care of for his grandmother. And he had all his questions answered and more knowledge about elder law than any Google search can pull up. And I really encourage you to not rely on Google. It can really cause problems because there's a lot of unique things and nuances that just are not resolved by quick Google searches or even long Google searches. So we really feel rewarded when we can help people like this and help them move into a good situation from a difficult situation. So I've given you a ton of examples, and I'm thinking, and what we find is that you'll have situations you're not sure if we can help. This is what we recommend. Send us the referral, connect us with the person, because we will take the time with them we know the questions to ask, to understand, and see how we can help. And we'll help them in the least expensive, least hassle way possible. And so we'll talk about that more later. But to the extent it's confusing, overwhelming, you're not sure exactly about a certain situation, we'd be happy to talk to you or talk directly to the client. Whatever is most helpful for you. So you have hung with me for 50 minutes. You've done great. What questions can I answer for you today? You can put them in chat, and we can also unmute you. Do you want to unmute Sally, Megan? Or do I need to do it?
I think you might have to.
Okay, I got it. Sally, you've had your hand up a long time. Did you still want to say something? Thank you for your patience. Oh, how about if I unmute you? I can't allow her to talk, Megan.
Oh, yeah, maybe just put questions in the chat. I'm not sure.
I'm sorry. It's the Zoom restrictions. So if you could please put in chat, Sally, what you want to say and any other questions. No questions?
I can't get it.
Sally's talking now. I think she got it.
Sally got it?
No.
Sally, how are you?
Good. How are you? Can you hear me?
Yes.
Yeah, I'm so honored that you came to my talk.
Well, thank you. Thank you for doing this. It's such a complicated topic, and I take solace in hearing, you talk about your cases. They're complicated and difficult, and can take a long time to resolve. Can you hear me okay, Margaret?
I can, yeah. I agree, but I always think really it takes so much courage on the part of the family members. I always really respect them, but yeah.
Right. Mm-hmm. I know, because it takes a lot for them to recognize in the first place that there is a problem.
Yes. They're the heroes. But
right.
You've done some guardianship conservatorships, have you, Sally?
I have, yep. I've done some, and every case is different. I always marvel at how the facts are different, the financial situation can be different, the proposed, guardian or conservator's relationship to the ward or protected person can vary, and it just it seems every combination is possible. And trying to figure out, as you said earlier, always trying to look for the least restrictive alternative and trying to figure out what that might be, that can be very challenging. So I really appreciated hearing your stories.
Good, thank you, Sally. Sally is also a litigator or an attorney who specializes in going to court and works with, among other things, these kind of guardianship and estate dispute kind of situations. So if I had a really messy one, Sally would be one of the people I would refer it to, and I have done that. Yeah. But I've done kind of messy ones, but.
Right. I have a question for you, Margaret. How often do you find that a power of attorney is not enough, or even a healthcare directive, and so you have to do, so go to the next step? Sometimes that can be hard to determine, go to the next step of petitioning for guardianship or conservatorship. It
can. I guess, I haven't had any that were really tough, because there was the one where the husband died and he was the only one on there. Mm-hmm. And then it's the family disputes. And that's what I think is the hardest, because, there's just a lot of personal things to wrestle through, and like, how bad is it, and kind of gathering information. If the power of attorney says they have to make accountings reports, I like that, because we can always say, well, let's just ask them for the accounting and look it over and see how it looks. I'm trying to think of other, those would be the main ones. If somebody's not handling it right, or there's just nobody there. That's what I've run into. Mm-hmm. I'm sure we could talk a long time about other things. Okay. So I have a question for Peter. Is that okay, Sally, for now?
Oh, sure. Absolutely. Thank you, Margaret. Thank you.
You're welcome. I'm going to read Peter's question to the group. In the nursing home setting, what is the best process for getting a surrogate decision maker in place? The resident is in a protective environment. There's no pressing need for a guardian. Got it. You're using the right terms. Okay. However, there are cases where there's no involved family member, and the resident would benefit from someone speaking on their behalf. So, okay, really good question, Peter. I would say if this is not, if the resident isn't able to like talk to us, then it might, in this kind of a case, fall to you or somebody at the nursing home. And what we'd be willing to do is call, and you probably talk to Megan first, and she'd pull me in if needed, to determine what's the best process for the surrogate decision maker. If they're indigent, there's some government programs we could probably point them to. But this is a really good question, but sometimes it's better to be proactive and do it ahead of time. So if they have, so what I'd be looking at, I'm trying to answer this as best I can without having all the facts of an individual situation. You know, do they have capacity to appoint people? And then I'm kind of assuming they don't. So if they don't, then of course it's much more complicated. And we'd have to look at, practically speaking, if we can talk to the client or if there's somebody there or what the situation is. Those are particularly unique, I would say. We've had some we referred to where we had the county ended up stepping in and taking action. So that's a kind of a lawyerly non-answer kind of, it depends. But we're happy to work with you and talk it through with you. Oh, great. Wow, that's great. I covered all the bases with my guessing. Okay, well, it is, okay, Heather, I'll do Heather, then I'm gonna, there's some stuff I have at the end that I wanna make sure you hear about because I have a couple offer things for you that I want you to understand going forward because we can only do so much today. Heather, I often work with families who insist their loved ones are not safe at home and want to move them to the facility, but the loved one wants to stay at home. Totally, totally, I know. We know. There is a healthcare directive in place and the loved one no longer has capacity, but they refuse to move. And so what happens in a lot of situations like that, the family member will call us and they'll talk to us. And then a lot of times they hire us because they don't have capacity unless they have power of attorney for the client. And then they can hire us on behalf of the client. So we sometimes represent the family. We sometimes represent the person. Okay. And yeah, it really takes some sorting through of that. And we are very familiar with this. And we've done things where, okay, let's have care come in for a while. You bring in that third party and then they start pointing out that mom's not so good here at home. And that adds a lot more credibility. And then what is the doctor saying? Let's look at that. And then we can help move them into something that works better. Or they start getting the 24/7 in-home care and they realize, well, it costs too much, I need to move. And it's a process. But we help people with it all the time. So it's another one, I feel like I'm not answering you the best, but I would refer them to us. I would. We take the time, let me explain what we do. Because there's lots of situations like that we need to know more before we can kind of think about it. And think about how we'd advise them. So I'm going to move on to just letting you know how we can help you going forward. So we are here to help you. We want to be a resource for you and the seniors and the families that you work with. There's workshops. This will just be quick. And then I want to talk to you about how to send us referrals and what we do for people after, so you can feel comfortable about that. And let us know how else we can help you. So the first thing is this workshop today. It is an example. Of course, I do them on Zoom now, and we're getting better all the time at doing them webinars. Some really popular talks are about how your will may be failing you, how to avoid losing your life savings to the nursing home. That is really important, and that can help people like in that last situation actually. And then your choice, people, senior professionals come up with great ideas about what would really help you. So I'd be happy to do that. You can let us know about that. More often probably though, you might be sending us a referral. So the best way to do that, and by the way, we love professional referrals. You guys are in the situation where you see these people, you know, everything's coming down in them at once, and all of a sudden, you know, they fell and broke their hip, and now we're going in the home, and there's so much going on. They're so overwhelmed. They don't even know about what an elder lawyer does, or they don't know what you do. You know, I think it's really important that we keep referring to each other in this process. So our favorite clients come from professional referrals. The best way to send a referral is, I recommend email. You know, you can't just give us the phone number and we call. That's a violation of our ethical rules, because they don't want us to be ambulance chasers and hound people. If you want to send an email to the client and to Megan, then we have authority where we can follow up. So that's kind of the easiest way that most people like to do it. And what happens afterward is that Megan will contact them and set up an initial call and answer questions and make sure that they're a good fit for us, or it's something we can help with, so we don't waste their time or ours. And they all are entitled to a free confidential session focused on their individual needs. And then we'll send you a thank you note, so you know they contacted us. Under the ethical rules, we can't tell who hired us. They can tell you, but we can't unless we have their permission. But we'll send you a note so you know they called, because a lot of times getting them to call us is the hardest thing. And that's why the email seems to work better for a lot of people. So the next meeting that they have after that first touch point phone call with Megan is a strategy session for potential clients, which they can schedule online if they want, or Megan will schedule them with it. It's private, it's confidential, and it's complimentary. It's free. It's not pressure. Okay. We want to educate and empower them so they can make the best decision if they should start moving forward with us. So during that meeting, it's usually about 45 minutes long, and it can be over Zoom, it can be in person. Megan listens, asks a lot of questions, explains, yes, we can help, or no, we can't, or I got to check with Margaret, or whatever. And then so they kind of know this is the process, the cost, what to expect. So they get personal attention, and we answer the questions. Of course, we can't answer, like, will a guardian be appointed in my case? But all the questions we can answer at that point, we answer. And so then at the end of the time, your referral is going to know how we can help, if we can help them, the process, the cost, and they're educated and empowered to decide how to move forward and best protect them and their loved ones. So that is our goal. And we want you to know that we help clients throughout Minnesota and Wisconsin. Thank you to COVID. It's easy for us to serve people anywhere throughout the state. And we do estate planning. So like wills, trust, power of attorney, healthcare directive, probate, that means after people die, we help. And then elder law for seniors and special needs. And just a little more detail about elder law. It includes asset protection. That's where, like, hey, somebody's, maybe if they keep living, they're going to go on medical assistance in a few years. How can we best spend their money to protect them? And I want you to know about this game changer. I can't go into it, but it's Medicaid compliant annuities. They're new in Minnesota in the last 5-6 years. A lot of our clients really like them because they can save 50 to 80% of their assets legally and still qualify for medical assistance, still private pay for a good period of time, and get good care and good facilities like you guys work in. We also help with medical assistance applying, all the different programs, special needs trusts. This is all, anybody who is maybe considering guardianship, conservatorship, they potentially might need these in addition or instead of that. So we kind of cover that gamut of elder law. And so I want to thank you for being here today. And, oh, I forgot my personal guarantee. We listen to the concerns. We learn about each situation. We really try to take the time for that. And we'll be honest about if we can help. And if not, and try to refer them out to whatever kind of help we think they need. And we do our best to provide value to you, like today and every day, and to your referrals. So a lot of the questions, you can definitely call Megan, but I think it might save you time if you refer them to us, and then we'll take the time to see if we can help. So thank you for attending. We're going to send you by email red flags for elder law help. You can maybe share it with your team or put up in your office. It's just the kind of things we can help with. And some of them aren't so obvious. So we want to be partners with you on the team that supports seniors and their families in really trying circumstances. And so thank you again for being here. And we'll stay on for a few more minutes, but it is 11 o'clock. So thank you for your time. Thank you, Heather. I'm glad you liked it. I don't know if we can unmute people, Megan.
We should be able to.
Or do they? I think Sally unmuted herself before too. You're welcome, Jessica and Kim. When you get the reply email too, we'd love any feedback on how to improve. This particular talk I've given a few times. It's my first webinar version though, so it's a little harder when you can't see people's faces. Oh, thank you, Sally. Very kind words. Thank you, Peter. I agree. It's really important. I really love when people plan ahead and have their paperwork and then they don't need this usually, but
Sure.
but you guys I know are probably seeing a lot of the people who have the problems and it's too late to plan. Especially with COVID, I mean, it's a little harder to meet with people and have their documents signed, but we've been able to do it quite a few times. Okay, any other questions or concerns? Oh, I forgot to say, you can also, that strategy session, you can schedule an appointment to talk with Megan if you had longer questions that you want answers on. So that applies to you as well. Okay, I think there's no other questions or comments. I hope you all have a wonderful weekend. I first thought no one would be here on a Friday morning in August in Minnesota, but I'm very impressed. And really appreciate it that you took the time to come out. So have a wonderful weekend. Thank you.